Hi everyone, welcome back to the channel. This is Ishita, the legal intern at LEXIS and Company. Today I'm gonna tell you all about the Places of Worship Special Provision Act 1991. So let's get started. The Supreme Court asked the Centre to respond to a plea challenging the Places of Worship Special Provision Act 1991, which freezes the status of place of worship as it was on 15th August 1947. In agreeing to the examined law, the court has opened the doors for litigation in various places of worship across the country, including Mathura and Varanasi. About the Places of Worship Special Provision Act 1991, it seeks to maintain the religious character of places of worship as it was in 1947, except in the case of Ram Janmabhoomi Babri Masjid dispute, which was already in court. What is the purpose? Section 3 of the Act bans the conversion of a place of worship or even a section of it into a place of worship of a different religious denominations of a different segment of the same religious denomination. Section 4(2) says that all suits, appeals or other proceedings regarding converting the character of a place of worship that were pending on 15th August 1947 will come to the end when the Act committees and no fresh proceedings can be filed. However, legal proceedings can be initiated if the change of status took place after the cut-off date of 15th August 1947 after the enactment of the Act. The Act also imposes a positive obligation on the state to maintain the religious character of every place of worship as it existed at the time of independence. This legislature obligations on the state to preserve, the protect the equality of all faiths is an essential secular feature and one of the basic features of Indian Constitution. Exemptions. This disputed site at the Ayodhya was exempted from the Act. Due to this exemption, the trial in the Ayodhya case proceeded even after the enforcement of this law. Besides the Ayodhya dispute, the Act also exempted any place of worship which is an ancient and historical monument and archaeological site covered by the Ancient Monuments and Archaeological Sites and Remains Act 1958, a suit that has been finally settled or disposed of, any dispute that has been settled by the parties or conversion of any place that took place by before the Act commenced. Penalty. Section 6 of the Act prescribes a punishment of maximum 3 years imprisonment along with a fine for contravening provisions of the Act. Supreme Court's view in 2019. In 2019, Ayodhya verdict, the Constitutional Bench referred to the law and said it manifests the secular values of the Constitution and strictly prohibits retrogressions. Petition's argument. It has been challenged on the ground that Act violates secularism. It has been argued that the cut-off date of 15th August 1947 is arbitrary, irrational and retrospective, which prohibits Hindus, Jains, Buddhists and Sikhs from approaching the court to reclaim their places of worship which were invaded and encroached upon by the fundamentalist barbaric invaders. It is argued that the centre has no power to legislate on pilgrimages or burial grounds, which is under the state list. However, the government had said it could make use of its residuary power under entry 97 of the Union list to enact this law. Entry 97 confers residuary power to the centre to legislate on subjects that are not enumerated in any of the three lists. So guys, that was all with the news. I hope you got some knowledge and I hope you enjoyed the video. Please do like, share, comment, subscribe the channel. Thank you.